On May 9, 2023, Calvin Riley Sr., the defendant, was charged in Lyon County, Florida, with driving under the influence and operating a vehicle with a suspended license. Later, on February 16, 2024, Mr. Riley's legal team filed a motion to suppress statements he made before being read his Miranda rights and to challenge the admissibility of a liquor bottle found in his car, which Officer Kirstston of the Tallahassee Police Department had opened and partially consumed. In an order issued on February 28, 2024, Circuit Judge Jason Jones agreed to exclude some of Mr. Riley's statements, but ruled that the jury could still consider the evidence regarding the liquor bottle, leaving it up to them to determine its significance. The case moved forward to a jury trial on Friday, April 5, 2024. Certified legal intern Emma Hershey presented the opening statement for the prosecution, explaining that Officer Oliver had simply made what she called a mistake in opening the bottle. She further argued that evidence showing Mr. Riley's impairment existed even before the bottle was discovered.
May it please the court, defense, members of the jury. It was 2 a.m. and he was driving with no headlights on. It was 2 a.m. and he admitted to drinking alcohol. And he admitted to being at a local bar. Good morning, members of the jury. My name is Emma Hershey, and I'm a certified legal intern with the State Attorney's Office here in Florida. We represent the people of Lyon County. And we're here today because the defendant in this case is charged with 2 things. First, he's charged with driving under the influence. And second, he is charged with driving with a suspended or revoked license. These are 2 things that we talked about during jury selection, so I just want to briefly go over what to expect for the state to prove in this trial. So first, driving under the influence. There's 2 things that the state must prove. First, that the defendant drove or he was in actual physical control of a vehicle. Now, actual physical control of a vehicle, that doesn't mean that you necessarily have to be driving down the road when law enforcement encounters you. All it means is that you have to operate a vehicle, be capable of operating a vehicle. Now, we expect in today's case that you're going to see that this element will be easily satisfied. You're going to see in body-worn camera footage that the defendant was driving his vehicle. So we expect that we're going to establish that element. The second element that we must prove to you today is that while driving or in actual physical control of a vehicle, the defendant was under the influence of alcoholic beverages to the extent that his normal faculties were impaired. This is another thing that we talked about during jury selection. What signs of impairment are. See, you're going to learn throughout today's trial that impairment isn't necessarily falling on the floor drunk or tipping over, struggling to walk. It can be something as simple as your vision is affected when I take my glasses off. It can be something as simple as not being able to follow instructions, struggling to find documents. It can be something as simple as slurring your words. But members of the jury, here's another sign that we expect for you to see in this trial. Anger and aggression and an outburst of emotion. That's another thing to look for as we proceed. The second charge in today's case is that the defendant was driving with a suspended or revoked license. Now, this charge has 3 different elements that we have to prove to you here today. The first element is that the defendant drove a motor vehicle upon a highway in this state. Now that applies to any roadway really here in Florida. So if you hear that the defendant was driving down we expect that you'll hear that the defendant was driving down Monroe Street when this incident occurred, that he was driving a vehicle. That brings us to our second element. Number 2, that at the time he was operating his vehicle, his license was suspended. You're going to learn in today's trial that the Department of Highway Safety and Motor Vehicles issued a notice of suspension to the defendant. Not once, not twice, but 3 times before he was stopped on May 7th of 2023. that they sent this notice to his P.O. box that he specifically requested them to send his mail to. So we expect that we're going to establish that element here today. Third, we have to prove that at the time the defendant knew that his license was suspended. And this kind of plays with element 2. We expect that you're going to learn that because the defendant had access to his P.O. box, he had the ability to know of it, and he had notice of it because he was sent it 3 times in the mail. 3 times. Now, the judge is going to instruct you that anything I say during opening statements, and if the defense chooses to give an opening statement, that anything they say should not be considered evidence. While we're doing in opening statements, this is a general guideline, a roadmap as to what you can expect in today's trial. Kind of like painting a picture. So that's what I want to do for you. It's May 7th, 2023. 2 Tallahassee Police Department officers are on the side of the road on North Monroe Street, responding to a completely different traffic stop. And as they're responding to this different traffic stop, they notice a vehicle traveling at a high speed, whipping down the street over the speed limit. And at first glance, it might sound like it might just be a speeding ticket, but it wasn't just an ordinary, usual speeding incident. This wasn't an ordinary traffic stop. Because the issue is that the vehicle was traveling with no headlights on. Like I said, this happened at 2 a.m. in the morning with no headlights on North Monroe Street, which is a busy road. So seeing that this car is driving down the road with no headlights over the speed limit, one of those officers, her name's Officer Kirstston Oliver. You're going to hear from her today, and she's going to get on the stand, she's going to testify about her observations. She's going to tell us about how she hopped into her patrol vehicle and decided to pursue the vehicle, how she had to speed up to try to catch up with it. And as soon as she's finally close enough to finally put her headlights on and her emergency lights, you're going to learn about the defendant's driving pattern. You're going to learn that he was swerving. And when he was swerving, he almost swerved into another vehicle in the right-hand lane. That's finally when he stopped. You're going to learn that, yes, he put his blinker on. He put his blinker on. But did he get over to the side of the road? No. You're going to learn that he didn't get over to the right-hand shoulder. He didn't get over into a safe area to park. You're going to learn that he stayed in the middle of the road. In fact, his tire wasn't completely over into his lane. Close enough that another passing by car could have potentially sideswiped him. Now, members of the jury, you're going to learn from Kirstston Oliver that at that point she got out of her vehicle to go speak with the occupant of it. When she approached the vehicle, she noticed one individual alone inside of it, the defendant. When he rolls down his window, I want you to pay attention to the body-worn camera and look for the signs of impairment. You're going to hear about how law enforcement officers are trained to look for signs of impairment and what specific things can point to alcohol impairment. Members of the jury, what I'm asking from you in this case is to stick to the facts and look to the facts of the case. The facts will guide you throughout this trial and throughout your deliberations. You are sworn to uphold the law and the law alone. And the facts are simple. He was driving. He admitted to drinking alcohol. He admitted to being at a bar. Notice was sent to him 3 months in a row saying your license is suspended because you don't have insurance. And he still chose to drive despite knowing his license was suspended. He still chose to drive because even though he knew he had drank alcohol. The facts are simple. At the end of today's trial, you're going to hear from all the witnesses who are necessary. You're going to have the opportunity to review evidence and video footage. And at that point, We're confident that you're going to see the truth, that the state has met its burden, that we've proved this case to you beyond a reasonable doubt. Not a mere speculative doubt or forced or imaginary doubt, a reasonable doubt. You will see the truth, and the truth is that the defendant is guilty.
An opening statement is the first speech delivered to the jury by each side at the start of a trial. Its purpose is to give the jury an overview of the facts that the attorneys believe the evidence will show. However, it is important to note that an opening statement itself does not count as evidence and cannot be used by the jury when making their decision. In her opening statement, Ms. Hershey aimed to downplay the significance of Officer Oliver's handling of the liquor bottle. She described it as an unintentional mistake and guided the jury to focus instead on the other evidence indicating Mr. Riley's impairment, which she argued supported the prosecution's case. On the other hand, Assistant Public Defender Desiree Goodfellow delivered an opening statement outlining Mr. Riley's defense. She argued that Officer Oliver had manufactured evidence against her client by falsely claiming to have detected the smell of marijuana and by opening and partially consuming the alcohol bottle found in his vehicle.
Calvin Riley is innocent. This case involves an officer planting evidence. I'm not going to sugarcoat it. What you are going to see from the officer is shocking, it is egregious, it is outrageous. It is not an innocent mistake. There is literally an officer on camera making evidence where none existed. And I expect all of you will get to see with your own eyes. Officer Kirstston Oliver of the Tallahassee Police Department stopped Mr. Riley for his headlights being out. She claims she smells marijuana. You will hear Mr. Riley protest. He does not smoke marijuana. The claim that she smells marijuana is what lets her search the vehicle. Officers remove Mr. Riley from his car, put him in a patrol car, and then search his vehicle. They of course find no marijuana, not one bit. And that's for the simple reason that Mr. Riley does not smoke marijuana. However, it is what she does next that is truly shocking. Officer Oliver reaches in Calvin Riley's vehicle, grabbed a full, sealed, unopened bottle of liquor, cracked it open. You will actually hear the plastic seal break. It is a distinct sound. You're going to see it from the angle of her own body camera. She was too brazen to even bother turning it off. She then pours out some, but not all of the liquid, puts the cap back on, and then tosses the bottle back into his vehicle. She then lies and tells the officers that she found an open bottle. Mr. Riley was pulled over on his way home. I expect you will hear that while he was driving home, Officer Kirstston Oliver pulled him over for not having his headlights on. You will see how a simple traffic stop escalated based on what I expect you will hear Officer Oliver herself testify were actually just assumptions. You will hear from officers that Mr. Riley smelled like marijuana, but that's not even possible because as you will hear, Mr. Riley does not smoke marijuana, nor lets anyone smoke marijuana in his car. I expect that you will hear that no marijuana was found in the vehicle when officers searched it. Just a phantom marijuana smell. Mr. Riley has been charged with driving under the influence and driving while license suspended or revoked. You will learn that officers claim to initially have arrested Mr. Riley for driving while license suspended or revoked and not DUI because they didn't have probable cause for DUI when they arrested him. The judge will instruct you that the state must prove Mr. Riley had knowledge that his license was suspended when he was driving. You will hear Officer Oliver assume Mr. Riley knew without any actual proof. This is important because they are required to prove beyond a reasonable doubt that he knew his license was suspended. The state will rely on the officer's ability to smell. However, you will not see evidence that they found anything consistent with that smell. Judge Jones will instruct you that reasonable doubt comes from 3 places: the evidence itself, conflicts in the evidence, and a lack of evidence. Pay close attention to the evidence, not only the evidence you see and hear today, but also what you don't see and hear today. When at the close of evidence you have reasonable doubts as to what actually occurred, when the government has not expelled all reasonable explanations from your mind, justice requires that your verdict be not guilty. The evidence will show the police created a crime where none existed.
The prosecution argued that Officer Oliver's actions were simply an unintentional mistake and a minor breach of policy that did not affect the case. In contrast, the defense insisted that she had intentionally planted evidence in Mr. Riley's car to create the appearance of a crime that never actually happened. After a brief recess, the jury returned to the courtroom and the prosecution called Officer Oliver to testify as the very first witness in the trial.
If you'll just stop about right there, the clerk's going to swear you in. Thank you. You can have a seat. State you may proceed.
Thank you, Your Honor. Good afternoon. Could you please introduce yourself to the members of our jury?
Hello, I'm Officer Oliver with the Tallahassee Police Department.
Now, I want to turn your attention to a specific date. Do you recall May 7th of 2023?
Yes.
Okay. So, specifically before 2 a.m., can you tell the jury what you were doing?
So before 2 a.m., I was doing my regular patrols. I may have stopped a few cars. Directly before 2 a.m., I was back up for another officer for their traffic stop, just making sure that they were okay and safety reasons.
You said there was another officer you were with. Which officer was that?
That was Officer Muth.
Okay. Margaret Muth?
Yes.
Okay. So while you're at this different traffic stop, is there anything unusual that you notice on the roadway?
While I was on the traffic stop, I noticed a vehicle traveling behind me at a high rate of speed, and then I noticed that their headlights were off.
How fast are we talking about?
I would say faster than the speed limit, which was 45 in that area, so I would say maybe about 10 miles over the speed limit.
Okay. And I just want to be clear for the record, did you have any type of device that was able to ascertain exactly how fast he was going?
No.
Okay. So is it safe to say that that was something based on just your observation?
Objection, leading.
Overruled.
I'll ask the question again. Is it safe to say that your observation was, or your assessment of the speed was based on your observations?
Yes.
Okay. Is that something that you do in other traffic investigations or traffic stops?
Yes.
Okay. Can you describe to the jury the driving pattern of this vehicle?
Yes. So the vehicle that I saw was traveling without headlights on. Was traveling at a speed above 45. When I got behind it, it was starting to slow down, but it wasn't stopping. My blue lights were on, and the vehicle was kind of swerving in and out, crossing the line into the right-hand lane next to it, and it was, kind of just going in and out of the lanes, the lane it was in, and then the lane next to it.
So you see the vehicle put its blinker on. Does it get over into the right-hand lane after that?
No.
Does it pull over to a shoulder?
No.
Where does it go?
It pulls into a left-hand turning lane, still slightly in the lane that it was in originally.
Can you tell us what the defendant appeared like to you based on your training and experience when you first made contact with him?
When I first made contact with him, before all of the conversation started, I noticed that his eyes were watery, and that they were kind of bloodshot.
You mentioned that he looked into a center console.
Yes.
Okay. So later in your investigation, or actually, did you notice any containers or cups near that center console later in your investigation?
Yes, there was a Tervis tumbler.
Okay. Were you able to determine what was in that Tervis tumbler?
Not the exact contents, no.
What, from your understanding, based on your observations and your training experience, what was in that?
I smelled it, and it smelled to be alcohol.
Okay. when you were doing this, were you able to locate the defendant's information?
Yes, I was. I was able to verify it.
Okay. When you were able to verify him, did it have a picture of him?
It did.
Did it give you information about his driver's license?
Yes, it did.
Okay. So when you saw this, were you able to determine whether or not his driver's license was active at that time?
I was.
What was the result?
It said that it was suspended.
Objection.
Grounds.
Hearsay.
Overruled.
So walk us through your thought process when you were trying to determine if he had received notice of the suspension.
So when I spoke to him earlier, he said that he was coming from 429 West Brevard Street. And when I saw the address as the residential address that's listed on his driver's license, typically that is the address that you are residing at. And so when he mentioned the address, along with the address being the same on David, his driving record, I assumed that he received the notice of his suspension at that address, and therefore he knew that his license was suspended.
Officer, can you describe to us where exactly you found this vodka bottle?
Yes, so there was a cover on the seat, as you can see, and right where your knees would sit, like behind your knees, there's a little pouch, and it just kind of opens up if you stick your hand in there, and that's where I located the vodka.
How did you know it was vodka?
It said vodka on the bottle.
So did this vodka bottle play any decision or play any role in your decision to have him placed under arrest for driving under the influence or driving with a suspended license?
No, because it was found post his arrest.
Officer, we just saw you dump out some alcohol, so I want to walk through this with you. What was your understanding of whether or not this bottle was open when you first found it?
I did not know whether or not it was opened.
Did you check to see if it was open?
When I went to open it, yes.
Did you initially think it was opened?
I believed it to be yes.
At what point did you realize that it was not open?
When the seal broke.
Did you have to review your body-worn camera footage again to hear the seal break?
Yes, there was a lot going on at this traffic stop.
So when you dumped out this alcohol, why did you do that?
So typically when I find alcohol in a vehicle, whether it's a DUI investigation or just open container, because we all have discretion in misdemeanor crimes. We can choose whether to charge somebody with something or not. And in this case, I dump alcohol out if I find it. He was not charged with it. So my intention of dumping it out was solely to dump it out and get it out of the car. That was it.
During questioning by the prosecution, Officer Oliver testified that she poured out the alcohol from the bottle simply to get it out of the vehicle. However, according to Tallahassee PD General Order 42, which governs the impounding and handling of property and evidence, officers are required to make sure that all evidence remains uncontaminated from the moment it is seized until it is officially impounded. They must also maintain a fully documented chain of custody from the time the department takes possession of the item until it is lawfully disposed of. While the policy does allow officers to destroy and properly discard drug paraphernalia under specific conditions, it does not provide any similar rules for handling alcohol. As a result, it is highly likely that Officer Oliver's actions breach the department's evidence handling policies.
What other signs of impairment can you tell us about that you noticed?
So the excessive talking, the aggression, the constant just yelling over us, and the just talking about the same things over and over again, asking about the phone, and just repetition.
Did you ever raise your voice at the defendant?
No, I did not.
Once the prosecution finished its direct examination of Officer Oliver, the court called for a short recess. After the break, the trial resumed with the defense counsel beginning their cross-examination of the officer.
Officer Oliver, you pulled Mr. Riley over for 2 reasons, correct?
Correct.
No headlights is one of them, correct?
Correct.
And you believed he was speeding.
Yes.
You were actually at another roadside stop when you saw him.
Correct.
You didn't use a radar gun.
I did not.
You didn't use any speed measurement device.
I did not.
You just assumed.
Based on my training, yes.
You left the other stop.
Yes, I did.
You got behind Mr. Riley within a few seconds.
Yes.
You actually follow him for a while without even activating your lights.
No, that's not correct.
That's not correct.
No.
So that's your testimony here today.
Yes.
And you had your body-worn camera on during this time, correct?
Correct.
To be clear, you actually followed him for a while without even activating your police lights.
Objection asked and answered.
Sustained.
I was just clarifying, Your Honor, because previously I said lights.
Okay. Ask the question.
You actually followed him for a while without even activating your police lights, correct?
Incorrect.
That's your testimony here today.
Yes.
You were wearing a body-worn camera.
Correct.
You've received training on TPD's requirements for use of body-worn camera.
Correct.
Per policy for all traffic stops, your body-worn camera is required to be on.
Correct.
You did not activate your body-worn camera until you got in your car to pull him over.
Correct.
We see you following him.
Correct.
But your body-worn camera doesn't record him driving.
No, it's on my chest. You can't see it.
There is no footage of his driving pattern.
Negative.
That's incorrect?
I'm sorry, that's correct. There's no camera footage.
Your testimony is that he swerved in the road to pull over,
Correct.
but none of that is captured on your camera.
It's not.
Objection asked and answered.
Sustained.
Your testimony today is that he was swerving in and out into right-hand lane, going in and out of lane, correct?
Correct.
In your initial report, written the morning of his arrest, all you indicated, though, was swerving.
Is that a question?
Correct? Is that all that you put in your initial report?
I don't know. I don't have my report in front of me.
Would seeing your initial report refresh your recollection?
Yes, ma'am.
Now you've looked at your police report. It's true that on that report, you indicated just swerving, correct?
Objection. Improper refreshment.
Sustained.
May I confer, Your Honor?
Yes, you may.
Where you pulled Mr. Riley over was in the turn lane by the median, correct?
Correct.
There was no shoulder on the right for him to pull over to.
No sidewalk.
He uses his left blinker
Yes.
to indicate that he's turning to the left.
Yes.
You testified that you thought his eyes were glossy.
Correct.
He's wearing glasses, correct?
Yes.
The day of, he was wearing glasses, correct?
Yes.
And you wrote a report on May 7th, correct?
Yes, ma'am.
And you swore to tell the truth in that report, correct?
Yes, ma'am.
And in that report, you never said anything about him having bloodshot eyes. Correct?
Okay. Yes, correct.
You also did a deposition, is that correct?
Correct.
In which you were sworn to tell the truth?
Yes, ma'am.
And in that deposition, you also never said he had bloodshot eyes.
Okay.
So while you're at the window, he begins looking for the items you requested.
Yes.
Correct? He gives you his name and date of birth.
Yes.
He tells you that he can't find his license.
Correct.
Actually, when you search the car, you don't find it.
I don't.
When you called Officer Muth for backup, that's because you already suspected DUI, correct?
Yes, ma'am.
But you weren't 100% certain it was a DUI.
No, ma'am.
In fact, at that point, you hadn't even smelled anything, correct?
I was unsure. Yes, ma'am.
During the search, you found a bottle of alcohol, correct?
Yes, ma'am.
And that was found in a pouch on the front of the driver's seat.
Yes, ma'am.
During that search, you didn't find any marijuana.
No, ma'am.
You didn't find any joints.
No, ma'am.
You didn't find any paraphernalia.
No, ma'am.
You didn't find any evidence of marijuana besides a smell.
Yes, ma'am.
Before finishing the search, you went back to that 20-gram bottle that you left on the driver's seat,
Yes, ma'am.
and you picked up that bottle.
Yes, ma'am.
You opened that bottle.
Yes, ma'am.
That bottle was sealed before you opened it.
Yes, ma'am.
And so you twisted the top of the bottle,
Yes, ma'am.
and you broke the seal.
Yes, ma'am.
And after you opened it, you dumped out the contents.
Yes, ma'am.
You dumped it onto the road.
Yes, ma'am.
Then you put the top back onto the bottle.
Yes.
And then you put the bottle back into the car.
Yes, ma'am.
You threw it on the passenger side.
I did.
And has that always been your testimony?
Everything that you just asked. I did not know that I opened the bottle in my original testimony.
At a pretrial hearing, you swore to tell the truth, correct?
Yes, ma'am.
And you testified that you didn't unseal it.
Objection, Your Honor.
Overruled.
Yes.
So, at that time that was a lie.
Unknowingly, yes.
And officers rely on each other to write reports.
Yes, ma'am.
And that's because not every officer sees everything.
Correct.
And not every officer writes a report.
Correct.
Usually there's a primary officer,
Yes, ma'am.
and they're the ones who write the primary report.
Yes, ma'am.
In this case, Officer Muth was the officer who wrote the primary report.
Correct.
And you told Officer Muth about the bottle.
Yes, ma'am.
And you told her about the bottle because you were using it as evidence.
I told her that I found a bottle of vodka in the driver's seat. Now, whether she used it or not as evidence, that was up to her.
But she only knows anything about that bottle because of you.
Yes, ma'am.
And like you said, she put that in her report.
She put an opened bottle, correct?
And you would agree that an empty bottle would be evidence of a DUI.
Yes.
And that's an open bottle that you created.
Yes.
So you're the one who created the big evidence of the DUI.
I don't know if she used it as evidence.
Earlier today, you testified that you didn't get his middle initial, correct?
Correct?
And you said that you didn't even ask him for his middle initial, correct?
Correct.
Because you thought that he wouldn't give you his middle initial,
Correct.
despite him willingly giving you his name without any problems.
Yes.
Nothing further right now, Your Honor.
The defense counsel completed their cross-examination of Officer Oliver. After this, the prosecution had the chance to conduct a redirect examination, which allows the attorney who originally called the witness to ask follow-up questions. The purpose of redirect is to clarify or strengthen the witness's earlier testimony. It's important to note that questions during a redirect are limited only to topics that were brought up during the cross-examination.
What big evidence was in this car when it was being towed?
The only evidence I know of is she mentioned the bottle of alcohol and the cup that smelled like alcohol.
Okay. Officer, was that big evidence to your decision to arrest the defendant?
No.
Okay. When you're interacting with the defendant, can you describe to us how he smelt to you at that time?
He smelled overwhelmingly of alcohol.
When you were searching his vehicle, what did the vehicle smell like?
It smelled like alcohol and marijuana.
In your experience as an officer, is it uncommon to come across somebody or their vehicle that has an odor of marijuana and then not find marijuana inside?
Very often, yes.
Officer, was the alcohol bottle already in the vehicle when you searched it?
Yes, it was.
Now, I know we already covered this originally, but the defense brought this up, so I want to cover it again with you. When you opened the bottle of alcohol, did you have any reason to believe that it was opened or sealed?
Objection, Your Honor, asked and answered.
Overruled.
I did not know until it was opened that it was sealed.
The defense also asked you questions about whether or not you told Officer Muth that it was open. We watched the body-worn camera footage here in court. To your recollection of it, do you recall ever hearing yourself tell Officer Muth that the bottle was open?
No.
After Ms. Hershey completed her redirect examination, Judge Jones allowed Officer Oliver to step down from the witness stand. The trial then resumed on Monday, April 8th. The court acquitted Mr. Riley on the charge of driving with a suspended license, but the jury found him guilty of driving under the influence. Following the conviction, Mr. Riley was sentenced to 10 days in jail, 6 months of probation, 50 hours of community service, and a 6-month suspension of his driver's license. On April 17, 2024, Mr. Riley filed a motion requesting a new trial, but Judge Jones denied the motion on June 12th. He then appealed the conviction on June 17th, and on August 15, 2025, the First District Court of Appeal of Florida upheld the verdict, affirming his conviction. The proper preservation of evidence is crucial to maintaining the integrity of any criminal case. In this situation, Officer Oliver's handling of the liquor bottle fell far short of both departmental rules and constitutional standards. She not only opened a sealed bottle, but also poured out part of its contents and then carelessly placed it back on the passenger seat. This careless handling gave the impression of tampering rather than the careful and responsible treatment required for evidence. Although Officer Oliver later testified that her goal was simply to get it out of the vehicle,
This explanation does not follow established evidence handling protocols. It also fails to ease concerns created by her questionable choice to pour out only part of the bottle and then leave it on the seat. These concerns are further intensified by the fact that Officer Muth stated in his probable cause affidavit that an open bottle was found in Mr. Riley's car, using the tampered bottle as evidence against him. While Officer Oliver's true intentions cannot be known for certain, these inconsistencies weaken her credibility and raise serious questions about whether the jury was asked to evaluate evidence that may have already been compromised.